Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of Holly Schulker versus Elizabeth Kramer. In this case, we have a mother who is being deprived of their child. If you're saying to yourself, wait a second, didn't we recently cover a stream with this? Didn't we recently cover this case? No, we didn't. This is a different case. Here's another case with a mother being deprived of their child. We got a twofer here, so we're doing another one today. Sixth Circuit Court of Appeals. In this case, we got a mother who initially popped positive for a drug test, but then was shown to be negative for a drug test, and then the city decided not to care at all. They just pretended that they were still positive for no reason and basically were dicks. So we're going to read this case with this mother being deprived of access to their own child for basically no reason after the government knew better and try to figure out who's liable for what. So let's get started with this. In February of 2017, the St. Elizabeth Medical Center admitted plaintiff Holly for a scheduled in-labor birth. Prior to giving birth, St. Elizabeth tested a sample of the urine, which resulted in a presumptive positive for opiates. Holly did not consent to the testing. She was never told the testing would be performed, which, is always a little bit sketchy for a medical facility. Approximately 16 hours after the testing, Holly gave birth to her newborn without complications. Shortly after the pediatrician left the hospital room, Anne Marie Davis, a care coordinator and social worker, always our favorite people, with St. Elizabeth visited Holly in her room. Davis informed Holly that her urine had tested positive for opiates and asked Holly if she's taking any medications. Holly responded she recently taken some of her daughter's prescription cough medicine, and she eaten a bag of chips that contained poppy seed. As we know from Mythbusters, that can actually pop a positive test. Holly was unable to confirm if the cough medicine contained codeine, which Davis stated could be a positive result for opiates. St. Elizabeth did not perform a confirmation test because why bother? Known as a drug abuse within reflux to confirm test. On the first urine sample, even though the sample is still available. So even though they had the sample, they didn't do a confirmation test for some reason. Normally, if you're going to do a preliminary test to do as a screen, and you have a more severe test, why not just do the secondary test? You still have the sample, so why not? I don't know. Before receiving results for the test, umbilical cord testing, Davis charted that Holly had a positive drug screen, which is to say, wrote it on the chart, and indicated Holly had a substance abuse disorder, even though the records indicated that the prenatal lab tests had all been negative, and she had no history. So they had all kinds of prenatal history and prenatal testing, which showed no history. Now we're putting on a chart that we had a substance abuse disorder, so, good times. At some point after speaking with Holly, but before receiving results from the core testing, Davis reported to somebody via web reporting that Holly had a positive drug screen. So child services of some kind. Great. This report was received by Bethany Grimes, a centralized intake social worker with the center. Child services, man, I swear. Late in the afternoon, Holly and David were informed that the child could no longer be discharged because policy required staff to observe them for 72 hours for withdrawal. Which I don't necessarily know enough about the law to know enough to criticize, but on presumptive positive, that might be reasonable. But then again, you have the test, so why not just confirm it? You have the sample, but it didn't seem to happen for some reason. On the evening of the same day as the birth, two social workers, the defendants, Kramer and Kara, the case squad, visited Holly in the hospital room. Defendants asked Holly for the names of her other children, where they went to school, and inquired about the drug abuse. Holly insisted there was an error because she did not use drugs, worked at a child care center, was her son's basketball coach, and volunteered at the school cafeteria. Kramer asked Holly to submit to another test, and they agreed. Fair enough. Let's do another test. Okay, great, let's do another test. Holly's urine was tested for the second time at 7:55. The results for the umbilical cord test performed were still pending. Okay, great. So now we're doing some other test, and we got two tests pending. Fine. At that point, Kramer, who was still in training at the time, called her supervisor, defendant Allison Campbell. Campbell spoke with Holly and asked her, how did the heroin get in your system? When Holly insisted the test was a false positive, Campbell told her, well, until this gets figured out, you're no longer allowed to be around any children without the supervision of approved individuals. So again, without knowing a lot more about the case law, without knowing a great deal of detail, this seems like it might be okay, right? It's the same day of birth. We have a presumptive positive, but again, we could have done a confirmation test, but we're doing some confirmation tests now, and we're saying, okay, we're going to freeze everything while we're figuring it out. So far, probably okay, I would imagine. But of course, it's going to get much worse. As the second test, as the conversation with Campbell and why the toxicology results were, and they were pending, Kramer presents Holly with a predominantly handwritten single-page document entitled a prevention plan. According to the plan, Kramer explained to Holly that if Holly failed to follow through the terms, all children in her house would be removed from care, and after that, they'd seek a court order, which may or may not be legal, but, at least we're getting due process, right? The plan provided that Holly was required to have supervised contact with all children by approved supervisors until notified. Prevention plan. According to the plan, supervision meant Holly could not be alone, must remain within eye and earshot of all times, 24/7. That's a pretty severe sanction, but okay. Under these conditions, they signed the document less than 30 hours after giving birth, and under belief, if they did not agree, all the children would be taken under care, and after that, they'd seek a court order. So basically, they did it under pressure. Okay, great. So far, we're acting pretty aggressively, especially based on a presumptive test, especially when we had testing information that seemed to go the other way, especially when there didn't seem to be other indicia. We're acting pretty aggressively. But we might be within the bounds of the law so far. We have a purported positive test, and we're concerned. We're saying we're going to take the children away and then do some sort of due process review. I don't know enough to know specifically where that's legal or not, but it's not triggering the biggest alarm bells in my mind. Obviously, I have questions, many questions, but it seems like we're in the same day, same time period. We seem to be acting reasonably, so it seems like probably okay. But of course, we don't stop there, do we now? Nope. So let's see where it gets worse. All right. At 8 p.m. the same day that they gave birth, and approximately 2 hours after the plan, the second results came back negative. The night nurse called Kramer and left a voicemail. So huzzah. We have the results of this test. We've made a mistake. We have confirmed it. It's a negative test. We're all good, right? So we can just tear up that plan. Allow them to go home. Everything's fine, right? No harm or minor harm, but, we understand everything's great. So, of course, immediately, Child Services said, oh, we're wrong, no problem, and they released the order, and of course, none of those things happened. None of those things happened anyway. Let's press on. Between 5 a.m. and 6 a.m. the next day, Dr. James visited Holly's hospital room to check on the child. He told Holly he received a phone call from a social worker the day before stating that they tested positive for drugs and been informed that he believed the test must be negative. Fair enough. Okay, great. At 1:32 the same day, the day after birth, St. Elizabeth received the umbilical test results, which were also negative for any results. So now we have two confirmatory tests. We have presumably a second urine test, and we have a blood test. We're good, and we can do this stuff. Within 20 minutes, St. Elizabeth emailed the negative test to Child Services. The hospital is acting reasonably. Within 20 minutes, we sent them to Child Services and said, we're all good. And this is the point that Child Services said, oh, okay, right? Nope, of course not. Let's press on. Despite knowledge that both tests were negative, Child Services approved the discharge of the child only under supervision of the father and pursuant to the prevention plan requiring supervision. But you have active knowledge that we have two tests, and so it was negative. We have an umbilical cord test, blood test at this point, which is pretty freaking reliable, right? And we have a second test, and we're saying nope, and we have all these prenatal tests. So despite all those things, Child Services says nope. We're only going to give it to the father. We're still going to insist on all this stuff. It's like, what? Why? Why not tear up the order? It's no good anymore. A St. Elizabeth employee received a copy of the child discharge plans and charted that, per the plan, AMS missed discharge under supervision. At the time, both of them are approved supervisors. Okay, at approximately 11 a.m., they were permitted to take them home under the prevention plan. Fair enough. So at this point, David decides to hire an attorney. Holly contacted an attorney who advised her to take a hair test, hair follicle test. So we're going to do another test because hair keeps drugs for a lot longer. So we're going to do a follicle test to confirm, again, that this is all negative. So we have two different tests in place. Let's do a hair follicle test too. Why the hell not? And that will prove it. And that's when Child Services will relent. Of course not. No, let's press on. Later that same day, our heroes from Child Services went to a public elementary school to interview the children. Neither Kramer nor the other social worker obtained a warrant to conduct the interviews. They did not consent to the interviews and unaware of the interviews being conducted. So we've got our social worker friends going to the elementary school to interview the children without a warrant, without notice, and without consent of the parents. Great. That's in no way concerning, especially after active knowledge that the tests were wrong, because you know that for a fact. Let's still go interview them and ask the kids about the drugs. That sounds good. On multiple occasions that week, Holly's counsel, the attorney, requested that Campbell or Kramer issue a finding of unsubstantiated and close the case, given the evidence of false positives. Each was denied without request, without explanation. So the attorney, doing their job, is repeatedly saying, hey, social workers, why not close the case? We have a blood test, we have a confirmed test. Why not just say it's unsubstantiated? We can all move on with our lives. But the social workers, without explanation, are denying it. Okay. On Thursday, February the 16th, at the counsel's request, they took the hair follicle drug test in order to further negate it. The result of the test were negative, and they emailed those results on the 21st. Okay. That's just getting better and better, right? So counsel emailed Campbell, Kramer, and the staff to inform them that no longer abide by the restrictions, and any further action must be pursued by the court. Okay, great. After Holly's counsel email, Campbell decided to contact her supervisor, Jessica Brown, for guidance regarding the lift. In a phone conversation, Brown told Campbell to lift the plan. Later the same day, Brown sent an email to Campbell to respond to the attorney, inform her they agree a negative hair follicle test, in conjunction with other information, warrants lifting the supervision plan at this time. We'll be reaching out to the family. However, Campbell did not send that email to Harry's counsel and did not inform them that they were no longer under the restrictions. They didn't bother to inform the people, right? All right. So over the next 6 weeks, Holly counsel and Holly made repeated requests, but they would not lift the plan, okay? So are you catching what's happening here, right? So, like, the hospital said, like, we'd like to, fix this, and the child services said, yeah, we'll be reaching out to them. And then over the next 6 weeks, the attorney is reaching out repeatedly to child services, and they say, we're not going to lift the plan. Despite the blood test, despite the secondary test, despite the hair follicle test, we're not going to lift the plan. You will bow to our will. We will maintain our plan. All the evidence in the world cannot convince us. Child services can suck my, you know what. This is just, good stuff. Good stuff. By which, I mean, horrible stuff. Absolutely horrific stuff. This is, The plaintiffs initiated a 1983 lawsuit. You don't say. Why would they do that? Why would they sue the government for deprivation of civil rights? What civil rights? Oh, that's right. Plaintiff filed a Second Amendment complaint, which is operative. They alleged that defendants violated the children's rights to be free from unreasonable seizures by subjecting them to interviews. They alleged the defendants violated 14th Amendment rights, the substantive and procedural due process, by imposing the plan's supervision without any procedural protection, even after there's no reasonable suspicion. Yep, sounds like it. What are these people's problem? I don't know what's going on. The district court denied summary judgment, rejecting defendants' qualified immunity defenses. Thank God. The district court found children had a clearly established Fourth Amendment right to be free from unreasonable seizure, which was violated when they conducted the warrantless in-school interviews. Also suspicionless, because you knew better. Further, the district court found the plaintiffs had clearly established substantive due process right to family integrity, and plaintiff produced such evidence to create a genuine dispute as to whether the defense violated that right. Sounds a little bit like they did, yes. Lastly, the district court found the plaintiff had a clearly established right to procedural due process before they could constrain a mother's contact with their own children. Let's talk about qualified immunity and whether it applies in this situation. Okay. A right is clearly established for the purposes of overcoming qualified immunity when a precedent has placed a question beyond debate. The purpose of qualified immunity is to give government officials breathing room to make reasonable but mistaken judgments by protecting all the plainly incompetent or those who knowingly violate the law. Kind of think we're there, but all right. As the Supreme Court has explained, qualified immunity balances interests, the need to hold public officials accountable when they exercise power, and the need to shield officials from harassment. The Fourth Amendment protects against unreasonable searches and seizures. I seem to remember reading that. For example, in the text of the Fourth Amendment itself. The court has held the Fourth Amendment warrant requirement governs social workers, just like any other government official. So in case you're wondering, social workers are not some sort of magic official that has some sort of magic power, even though they seem to think they do. Quite a lot for some reason. They seem to think they have superpowers that, like, they're not bound by that pesky Constitution. They really, really are. They're just state government officials. And yes, I know this will come to a surprise to children's services everywhere, but bear with me. You are actually subject to the Constitution. I know it's a shock, but you actually have to obey the Constitution. Don't listen to me. Listen to the court. It's right there on the page. A social worker, like other state officers, is governed by the warrant requirement. Pursuant to these principles, the children, through their next friend, that would be presumably their parent, and next friend here is a technical term, right? Just standing in the stead of, argue that Kramer, acting on the best of Campbell, violated the Fourth Amendment by seizing them from the public school classrooms and interviewing them without reasonable suspicion, warrant, or consent. A little bit. In response, defendants argue they're entitled to qualified immunity because it was not clearly established social workers are bound by the Fourth Amendment when conducting in-school interviews. And we're not bound by that pesky Fourth Amendment. We're special because we're child services, so we can conduct all the child interviews we want as part of state action. Sure, let's go with that. They point out neither the Supreme Court nor this court has ever held that analogous conduct by social workers violates the Fourth Amendment. For reasons that follow, we find plaintiffs did not have clearly established Fourth Amendment right to be free from warrantless in-school interviews by social workers investigating children at the same time. That is because our precedent is unclear about the role of the Fourth Amendment in the factual circumstances when social workers perform in-school interview pursuant to abuse. However, we exercise our discretion to consider the second prong of the inquiry and conclude that it's unconstitutional. We hold at a minimum social workers investigating child abuse must have some definitive and articulable evidence giving rise to reasonable suspicion that they've been abused or of imminent danger before seizing a child. So basically this court says, okay, you win on the first part of qualified immunity. It was not clearly established at the time. There was no case clearly established, so you win on the first part of the Fourth Amendment inquiry. But we do have this wonderful little caveat in qualified immunity cases, don't we? We do have where it was like so blatantly obvious. We don't need a case on point. Ding, 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 ding. Congratulations. You win the prize. Da-da-da-da-da-da. You win the prize because even though it was not clearly established at the time, you can't do this. So no. You lose. Good day, sir. Because we find the district court should have granted summary judgment in favor of the defendants on the Fourth Amendment, we do not need to decide whether the conduct was unconstitutional. However, after carefully considering the Supreme Court's guidance on whether a court of appeals should exercise discretion to reach an underlying constitutional question in a qualified immunity case, we need to reach the decision now in order to promote the development of constitutional precedent and promote the clarity of legal standards for conduct to benefit both the officer and general public. So, we don't have to do this. We don't really have to get to the underlying issue because we say it's not clearly established at the time. So, we don't really have to look to it and look beyond the veil. But for you, my friend, special press, we're going to look. We're going to do it. The Supreme Court has said sometimes we should exercise this discretion and look beyond to answer the question. And you know what? You're that case. Congratulations. We're going to look beyond. Aren't you thrilled? Hey, yo. The threshold question to determine if the Fourth Amendment rights were violated is whether they were seized. A seizure occurs whether a reasonable person would have felt not free to leave. Well, I don't know. A bunch of children in elementary school, when they're summoned by the authorities, would the children feel free to leave? Probably not. Seems good to me. Yep. The plaintiffs allege that per Campbell's instruction, Kramer and another social worker went to elementary school to interview the children, age 8, age 9, and age 9. And went to middle school to interview their fourth child, age 13. The social workers did not obtain a warrant or consent to conduct the interviews. Why would we need that? School personnel were not permitted to stay with the children. That's good. And each interview lasted 30 minutes. Holy God, it's a long time when you're a kid. During which the children were questioned about mommy using drugs, alcohol use, and whether there's any physical violence in the house. Man, these guys are special. These facts, when defendants have not rebutted, so the defendants haven't argued it's not true. So the kids say, hey, they asked me about mommy using drugs and alcohol use and physical violence. And the defense say, we're not going to contest that. Clearly demonstrate a genuine factual dispute as whether a reasonable child would feel free to leave. I don't know, would an 8-year-old summoned by a governmental authority feel free to leave? I'm going to go with no. That would not be reasonable for an 8-year-old to feel free to leave, yeah. There is some disagreement in the circuits regarding whether the special needs exceptions apply to social workers in school interview of a child pursuant to a child abuse investigation. This court has not spoken to the issue. So, all good rules. The Fourth Amendment does have rules, and there might be special needs for, an ongoing abuse allegation. Maybe there is some special need. The Fourth Amendment's touchstone is reasonableness. It's unreasonable searches and seizures. So, maybe if there's a child abuse case, a special need exception might apply. So maybe we can, do this interview anyway. But is that what happened here? As discussed above, in a decision that's since been vacated, the Ninth Circuit held the Fourth Amendment traditional probable cause standard applies to social work seizure from a child pursuant to a child abuse investigation. So the Ninth Circuit said even in the case of child abuse, it would apply, although they vacated that decision, so it no longer applies. But at least one court at one point had said that. Other courts have indicated a lesser modified reasonable standardness under TLO may govern the seizure of a child pursuant to an abuse investigation. So, maybe abuse investigations, we need some sort of special rules, we need some latitude. Okay. So in Jones versus Hunt, the 10th Circuit considered where a standard might govern social work interview of a child at public school pursuant to an investigation, but found it was ultimately unnecessary to determine whether it need exception because conduct in that case failed to under even the TLO standard. And you can say, we know where this is going, right? So there's been some disagreements in the courts about an ongoing abuse investigation. Maybe in an ongoing abuse investigation, we obviously can't get the parents' consent. I mean, come on. And we're doing an investigation, so we can't get a court order. We can't get a warrant. So what are we going to do here? We have suspicion. We want to ask questions of children. So what are we going to do? So there's been some disagreements in the courts, there's been some disagreements. But some courts have basically said, maybe we can bend it a little bit, in this circumstance, because touchstone is reasonableness. So maybe in an active abuse investigation, we could. The 10th Circuit said, in a similar case, where abuse didn't apply, we didn't need to do that. So, hey. Ricardo Ospania says in chat, not very likely these kids would be saying, am I free to leave, unless they're the youngest sovereign citizen ever. Very cute. Very well done. Well spotted. Yes. So the same is true here as in the 10th Circuit case. In that present case, we need not decide which Fourth Circuit Amendment standard governs the social worker's in-school interview of a child pursuant to an abuse, because defendant's alleged conduct fails even the modified reasonable test of TLO. We're not even close to that, yeah. Applying the standards to this case, we find defendant conduct violated the Fourth Amendment. Plaintiff alleges that the defendants conducted the interviews. They knew. See, this is all about the facts. The facts matter. What did they know? The defendants knew the St. Elizabeth staff believed the test was a false positive. They were including allowing them to breastfeed, which, that's a big deal when it comes to drugs, right? The second test was negative, and the results of the umbilical test was negative. So they knew all these things. Therefore, the plaintiff's alleged defendant did not have any plausible suspicion. Viewing the light most favorable, a reasonable jury could find it was not justified at the inception. Yep, because they knew it. Therefore, defendant's conduct in this case, alleged by plaintiffs, was unconstitutional because it failed to satisfy even a lesser modified reasonable standard as under TLO. Seizures were not justified at their inception, not reasonably related to the scope of circumstances which justify the interference. This is not a special case. You knew better. You knew for a fact, and you still did it anyway, so you're not covered by that. Welcome to the club. This court has held that it is clearly established that the Constitution recognizes both a protectable procedural interest in parenting a child and substantive fundamental right to raise one's child. Under the 14th Amendment, the parent-child relationship gives rise to a liberty interest a parent may not be deprived of absent due process of the law. Parents have interest in their children, yes. To start, we consider the substantive due process claims. The Supreme Court has repeatedly held it is cardinal, in other words, central, in other words, essential, with us that the custody, care, and nurture of a child reside first with the parents, whose primary function of freedom includes preparation for obligations the state can neither supply nor hinder. Thus, in our case law, the Supreme Court has declared it's plain, beyond the need for citation, a parent's desire for right of companionship, care, custody, and management of children is an important interest that undeniably warrants deference, and the absence of parent countervailing interest protection. Parents have an interest in raising their children, generally, yes. Indeed, with the many ways the right issue in this case, the right of family integrity and association, is a paradigm example of substantive due process. This is the paradigm example. This is what we had in mind. Therefore, the district court correctly found the plaintiff's right to make decisions of them without arbitrary interference was clearly established. Yeah. Defendants argue that interest in integrity was outweighed by the interest in preventing child abuse. Well, in the abstract, in preventing child abuse, you might be right. In the abstract, you might be right. However, as alleged by the plaintiffs, the state did not have any interest in protecting child abuse in the present case because they had no reason to suspect Holly of the child abuse at the time of supervision. Therefore, the district court correctly found the supervision contravened the traditional presumption articulated by the Supreme Court that a fit parent will act in the best interest of the child. Yeah, pretty much. Under the above cases, we find defendant had fair notice that the parents had a protected liberty interest in their children and the right to make decisions concerning their children without government interference. As discussed above, the plaintiff have a well-established right to their children, and the circuit has consistently held the Constitution recognizes the substantive right to raise one's child. There is no doubt that under our Constitution, the parent-child relationship gives rise to a liberty interest that a parent may not be deprived of absent due process. In the present case, when supervision restrictions did not deprive Holly of a physical companionship, they nevertheless constitute interference with the relationship. By arbitrarily mandating when Holly could be with her children, who had to be present, the prevention plan abridged the due process right to family integrity under the case law. Numerous Supreme Court cases have found a parent has a fundamental right to the companion, care, custody, and management of the children. After finding that the parents have a clearly established liberty interest and companionship of their children, we next consider where that right triggered procedural due process. Again, this court has triggered it does. So yes, you have a substantive right to your children. And the government wants to interfere with that, they actually have to give you process. Due process, in fact. It is due to you. And that didn't really happen here, no. In Smith versus Williams, Ash, this court recognized a limited exception to procedural due process in child removal. We held a hearing is not required when a parent voluntarily consents to a prevention plan. So if you have consent, okay, but did you? In contrast, well, that tells you everything you need to know right there, don't you? In contrast, in the present case, plaintiffs alleged their decision to enter into the plan was not voluntary. They contend their consent was premised on misrepresentations made by Campbell and Kramer that if they did not agree, the defendant would remove their children from care and seek judicial intervention. And the plan document itself provided that absent prevention, the children would be placed in foster care. Therefore, to the extent the defendants argue they are not required to afford the parents adequate protection, we find such an argument unavailing. It's not consent when it's made under duress. It's interesting too because I know a little bit about criminal laws that applies to this, right? So the police are generally speaking allowed to provide deceptions as part of their investigations, but there are limits, right? And one of these things is where it shocks the conscience of the court. And so for example, one of the things a police cannot say to induce you to testify or induce you to indict yourself is, we will take your children away. That's considered too much. You can't do that. No. You can't do that. You can't threaten a person's children. That's considered unduly coercive. So you can't do it in a criminal context. You can't do it here. It's we're going to take your children away if you don't sign this. Yeah, that's coercive. There's criminal law cases that say that. We've got civil law cases that say that. Too much. Nope. In addition, as the district court found, even if they voluntarily consented to the imposition of the plan at the start, they did not remain in the plan voluntary at all times. So even assuming somehow you had it voluntary at square one, which, duress and all, but, it was not voluntary on an ongoing basis. Yeah. The plaintiffs allege they made repeated requests to be released from the plan, including through their attorney, which incidentally is a very good reason to have an attorney, because an attorney can document all this. An attorney can show all this stuff, right? They can show all the things they did and all the letters they said. So it's this is a very good reason to have an attorney. They can validate all this. In addition to objecting at the hospital, the plaintiffs called the defendant that morning and requested a plan. They further alleged that they requested the plan to be lifted throughout that week and on multiple occasions throughout 6 weeks, including via their attorney. We repeatedly asked you. Nevertheless, plaintiffs alleged that without affording them any due process, they continued to impose the plan until April the 7th. Therefore, the district court correctly found this was a triable issue as to whether or not it was voluntary. I strongly suspect the answer to that question is no. As alleged by plaintiffs, defendants imposed the prevention plan supervision restrictions on Holly approximately 2 months after there was no longer any question as to fitness, for no apparent reason, it seems. In doing so, they abridged the plan, abridged the parents' clearly established right to companionship without arbitrary government interference in violation of law. Therefore, we are holding them responsible. So that is the end of our coverage of the case of yet another horror show when it comes to child services, which apparently is sometimes super, super dense. This was the case of Holly versus Elizabeth Kramer. In this case, we learned Kramer et al. There was an initial test that showed there might be some opiates. And then like 3 different tests said no. And they keep insisting on depriving them of their children. And they interviewed the children without consent and due process, all kinds of crap. So the government went way, way, way too far. Qualified immunity denied. Go back to trial, figure out if these things happened. And Elizabeth Kramer, Allison Campbell, and Kara, whatever your last name is, you're all responsible for this. And you can look forward to paying some damages. Big number damages. And I hope you choke on it. Because, you're clearly outside the bounds, and that's the end of this coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.